Hi, everyone. Thanks for coming to our seminar today regarding protecting your partnership, the contractual bones and the financial blood of a business. And to introduce myself, my name is Steve Blake. I'm an attorney licensed in California and Arizona, and I have a law firm in San Diego called the Blake Law Firm, where we handle real estate and business matters. Over the years, I've advised and consulted with numerous partnerships, both on the front end where we're setting up a partnership, putting in together the required documents, and then also during the duration of a partnership where, something comes up that the partners need legal advice on. And then I've also been involved in matters involving the dissolution of a partnership where there's either a dispute or litigation between the partners regarding the business. So over the years, I've been involved with a lot of partnerships, and I'm excited to be here today to talk to you about what I've learned.
And I'm Jo Barsa. I'm a CPA and the managing partner of Accuvisors. And although we work with all business entity types, working with partnerships is part of what we do from the very early stages to the dissolution or termination of a partnership and everything in between, including tracking of the numbers, keeping the financial statements on a monthly basis, and reviewing them with the partners so that we make sure that they understand their numbers.
So today, you're going to obviously hear from an attorney and a CPA. And what we want to explore together is strategies and information about how to be protective and proactive as a partner in a partnership and how to put in place good systems so that the parties can maintain a certain level of trust and preserve the partnership's value.
So we're talking about the prenup for partners and having ironclad agreements and financial guardrails that help guide the partners through, again, beginning stages all the way through the life cycle of a partnership. So we're focusing on the golden hour, which is the very beginning, and how to set up systems that make fraud or disputes mathematically difficult and also easy to identify if they are happening. The CPA's role in this from the very beginning is setting up a chart of accounts that enables the partners to understand their financial statements and their expenses. And it can't be too complicated, so as having to review 150 accounts, and it can't be too simplistic to where a bunch of things are bunched in similar accounts together and are hard to identify or have transparency. The other thing we do is we establish information rights, making sure that both partners have real time access not only to bank feeds, but any other information that they might need access to. If only one partner has access, say, to financial statements, the other partner is going to be kept in the dark, and that will erode the trust as quickly as anything. The other thing that's important in the early stages is determining guaranteed payments versus distributions. Guaranteed payments are compensation for the services of each of the partners. So they can be adjusted to reflect what each partner is actually doing for the company. So if one partner is working part-time, another partner is working full-time, the guaranteed payments can be adjusted to reflect that versus distributions, which are distributions of the profits of the company after the guaranteed payments are subtracted as an expense.
And at the beginning of a partnership, the attorney's role is typically to help the partners put together a written partnership agreement. And in California, it's not required to have a written partnership agreement. You can still have a legally formed partnership without it. However, having been doing this for 21 years, I strongly advise anybody that's entering into a partnership to have an actual written agreement. And I've seen different types of partnership agreements. They mainly look the same, but they can be anywhere from, a few pages to 100 pages, depending on the complexity and the nature of the business of the partnership. But the partnerships agreements are going to basically incorporate a lot of provisions from the corporations code in California, and it's also going to have really standard provisions about what the rights and responsibilities of the parties are, or the partners, who has authority to do what types of decisions need unanimous consent, what types of decisions can be made by a partner individually, what happens if a partner dies or if a partner wants to sell their interest in the partnership to someone else. And then importantly here in the second bullet point, like what happens if there's a disagreement between the partnership or the partners in the partnership on how to move forward on a particular decision. And sometimes what I've seen, if you don't have a deadlock provision, so to speak, it can create the end of the company because the company will just do nothing and stand still because it can't make a decision to move forward. So these are important provisions that can, be part of a partnership agreement and make it easier to handle company business if there is a deadlock, or if there's something that needs, unanimous consent as opposed to one partner consent. So that's really the attorney's role, is helping put that agreement together. And a lot of times when an attorney gets involved, the partners, have already spent hours and hours discussing the business and determining their role. So they may have a good idea already of what the terms are, but it's the attorney's job to put that in writing. And then that agreement is going to stay in effect throughout the duration of the partnership.
So here's a little checklist for spotting fraud and embezzlement before it destroys the business, and teaching partners how to audit one another without destroying the relationship between the partners. The CPA's role is what number one, looking for expense abuses. So making sure that the expenses that are being run through the partnership are truly partnership expenses versus going out to dinner with your spouse and running that through the partnership, or buying items for your home and running those through the partnership. Especially if this was not agreed upon up front. So, having alignment between the partners from the very beginning on what expenses are acceptable as partnership expenses and what expenses should be borne personally. Partners are able to deduct expenses that they pay on their own. They call it unreimbursed partnership expenses. So, if partners don't agree, perhaps, on what should be run through the partnership, and one partner, let's say, buys things for the partnership that they are responsible for individually, that partner can deduct that on their individual return. And there doesn't need to be a disagreement between the parties in order for that to happen. Also, establishing proper reporting standards. What reports are going to be generated every month and distributed to the partners? And this is whether there's 2 partners or 10 partners, it doesn't matter. All the partners should be able to understand what's in the reports, be able to ask questions if they have them, and also have regular, timely review of these reports. Having a report 3 months later isn't very useful in being able to catch and detect things that are going on before maybe it gets out of hand. So, timely reporting is also a critical thing to happen.
And from an attorney's perspective, when we get involved in a partnership that maybe there's some allegations of fraud or embezzlement by one of the partners, um, from a legal perspective, each partner in a partnership, whether there's 2 or 10, they all owe each other fiduciary duties. That's incorporated into the corporation's code. So they have a duty of loyalty and a duty of care to the other partners and to the partnership itself. So obviously, that would prohibit embezzling money. And there's also potential civil and criminal penalties that would go along with that. So, as a fiduciary, you have to act in the best interest of the company and the other partners, and you're not allowed to self-deal. And self-dealing can come in many different forms in partnerships. One thing, what Joe mentioned is, spending partnership funds on personal expenses. Another way it could arise in a partnership is if the partnership is involved in, building a building, and one of the partners hires their relative to, do some work on the project, and that relative isn't licensed, they're not in the business of doing this type of work. It's really kind of a favor to the relative. that could potentially be a breach of your fiduciary duty because of the fact that it's really self-dealing. Um, but once we're aware that there could be some fraud or embezzlement, the attorney's role is really to work with the company to help identify what that is, what has happened, what has taken place, securing the records, securing the assets, making sure that it doesn't continue. And that's why the reporting requirements that Joe mentioned are so important because if one of the partners decides to, let the other partner run the business and they go do something else for a few years and then they come back to check on things, that's 3 years of records that you have to look through. And it takes a lot of time and effort to do that. And I can tell you, partnerships that become involved in court litigation when they're fighting about expenses and money over the years, you have to hire a forensic accountant, someone similar to Joe, that comes in and goes through all the accounting records and tries to figure out what happens. And it's not an easy process, it's not cheap. So the prudent practice and recommended practice is to pay attention, look at the records, don't bury your head in the sand, and keep involved with the partnership, at least on, a monthly or quarterly basis. And finally, we've been talking about these problems that could arise. And the worst thing that can happen from an attorney's perspective is you end up in court fighting about this stuff because the court process, it's expensive, it's time consuming, and justice is not always served. So when it looks like there's a problem, or if one of the partners wants out and the other partner doesn't, or if they both want out, that's important to understand in the front end. Like, what's the intent of the partners here going forward? And typically, when it ends up in court, it's when one of the partners wants out and the other doesn't, which is why the valuations will be key and the accounting records are key because when that one partner leaves, there's typically a buyout of that partner's interest. And that's usually what the parties are fighting about is what is that amount? How much is the buyout worth? Because at that point, this party wants this party to leave and this party wants to leave. So everybody's on the same page with leaving. It's just about how much is that buyout. And I've had several cases that have gone into litigation because the parties haven't been able to agree on what that number is. So going back to the beginning, this last bullet point is when you're putting together this partnership agreement is to have provisions in there that help guide you through this, where you can decide on, if you're not going to be able to agree on the valuation at the end of the day, what process can we use to expedite that, such as, hiring a neutral third-party business appraiser and, using that as the valuation. So the key is
I
to stay
think,
out of the courtroom.
yeah. I think beginning with the end in mind is a very important point. Nobody likes to think about that when they're forming a partnership. They're typically excited about what they're doing, and they want to talk more about what's going to happen as it goes great, and they don't want to talk about how it might go if things go bad. But it's one of the most important things that you can do at the beginning that will keep the road kind of smooth. And just in case that happens, because it does happen in a large percentage of partnerships, that those things should be determined up front to avoid a lot of misunderstandings at the end of the line.
Yeah, and a lot of times too, like a partner will want to leave, but it's not necessarily because something bad happened. It's just they're not interested in being a part of the business anymore, and or they're moving to Hawaii and they don't have time to deal with it. So they want out, but they want to be compensated for their interest. And then, again, who do they sell it to? Can they sell it to anybody? Do they have to sell it back to the partnership? And all this stuff can be part of the partnership agreement that you're putting together on the front end.
So, in order to avoid a courtroom, the CPA typically is executing what the legal agreements say. So, the attorney is going to come in first and give the partners options on different ways that they could dissolve the partnership or terminate this relationship. And the CPA can evaluate potentially the tax implications of those things and advise the partners if you do it, the method A, here's what's going to happen from a tax perspective. If you use method B, here's what's going to happen from a tax perspective, and give them options to review and see what's going to work best for all of the partners. Also, having a valuation at this point, unless the valuation methodology is agreed to up front and incorporated into the partnership agreement, which oftentimes it's not, but that is a possibility that can prevent this step at the end. But if you're going to have a valuation by an independent third party, which is what we would recommend, so that there's no controversy over, well, this wasn't a fair valuation. Parties should agree in advance on the valuator who's going to perform the valuation. But they're typically going to want to see at least a 3-year look back on the balance sheet and P&L, and potentially other documents as well. They may want to review contracts. They're also going to look at the trend. So if the business has been trending up over the last 3 years, that's going to tell a different story and create a different valuation than if the business is trending down or staying static from year to year. You also want to talk about what's going to happen to the liabilities of the partnership. How are those going to be divvied up at the end if they exist? Is one partner going to take all the liabilities, but potentially take all of the assets that would be in play to satisfy those liabilities? Are they going to be split in accordance with the partnership percentages? Those are all things that you need to talk about, because those liabilities don't go away, unfortunately. And then also understanding the tax implications of a buyout versus a dissolution. So, as Steve was mentioning, if one partner wants to go move to Hawaii and have a nice lifestyle and maybe only wants to work part-time, but the other partner wants to continue the business full-time and continue to grow it, then maybe a buyout is a better option than, say, a dissolution. So, but each one of those things has different tax implications, and doing tax projections on what that would mean in both scenarios is a really important thing to help the partners make a decision on how they want to resolve this.
Yeah, and those decisions should be made at the time that, this dissolution is happening, because as an attorney, I've seen things where clients call and they say, hey, we have this partnership, and my partner, we need to put together the paperwork to get them out of the business. And, I asked, well, when did they quit participating in the business? Well, maybe 5 years ago. Okay, well, what have they been doing since then? And they haven't done anything, but they're still legally a partner of this business. So, it's important to take care of this stuff. But again, like I talked about in the previous slide, the first thing that we're going to look at is the partnership agreement when it comes time to dissolve the company, to figure out what it says, how to get each partner, out of the company and dissolve the company properly. Sometimes in these agreements, there's going to be a right of first refusal. So if a partner is going to leave, the other partner has the first refusal to buy them out. And the third bullet point is something that doesn't come up as often, but can come up, where let's say you have a partner that has just kind of checked out. They're not doing anything. They're not contributing. They're not, they don't have any role in the company. Is there a way to force them out of the company? Can we do that? And again, it might depend on what your partnership agreement says, but in a, partnership agreement that an attorney drafts, typically there's going to be something in there about a partner that's, not contributing, not performing, or maybe they did something that they shouldn't have done that, was against the interests of the partnership. Can you get them out? And sometimes it's not easy because that person doesn't want to get out. And lastly, to avoid a courtroom, if there is a dispute and the parties can't seem to find a meeting of the minds, I always recommend trying to mediate the case. And mediation is a voluntary agreement where the parties sit down with a mediator who's usually a retired judge or an experienced attorney. And it maybe is a full day where the whole point is to try to settle the dispute without going to that next step of filing a lawsuit. So mediations have been very successful in these types of disputes. A lot of times the partners they really haven't talked since the dispute happened, and it's good to get them in a mediation where the mediator can control the conversation and try to find a way to resolve it. Because I can tell you, if it does go to litigation, it can get very expensive and it can take a long time to finally get to a resolution. So that's it for our presentation today. I want to thank you very much for watching. And again, I'm Steve Blake. I'm an attorney at the Blake Law Firm. Our contact information is on this slide, and I hope everyone enjoyed.
Thank you.